Now we have with us Mr. Shubhadeep Sarkar, who is the Vice President of Cognizant and manages their intellectual property, technological licensing, and legal operations of the company. He also serves as the board. He also serves on the board of directors for several of Cognizant's APAC subsidiaries and is responsible for driving and establishing the IP and technology licensing strategies of these companies. Mr. Sarkar has had extensive work experience in the field of technology and IP, and he specializes in managing multi scenario IP strategies, IP risk and compliance management, licensing and commercialization of the intellectual property, as well as mergers and acquisitions of the several companies that he heads the board of. He also speaks frequently at several industry forums, conferences, and workshops, and has written and co authored several essays, book chapters, and articles as well in international and national journals. He's also a recipient of various awards in the international and national forums. Today, he'll be speaking with us about IP prosecution and litigation, what is often overlooked. So, sir, without much ado, it's over to you. We're looking forward to hearing from you.
Thank you. Thank you so much. Is my voice audible, clear? Just want to do a check.
Yes, sir.
Okay,
You're
great.
visible and audible.
Okay, great. Thank you. And firstly, thank you, Nalsar, and thank you to the IPR chair, Dr. Anindya Sarkar, for inviting me. Though the time I think that is allocated to me is 45 minutes, including Q&A. So I'll try to just do justice within the timeline. I'll share a few slides just to have these discussions in a rightful manner. Let me know once you're able to see the slide. Are you able to see? Okay, great. Okay, now patent prosecution and litigation, what I wanted to cover is two aspects given the time that we have. One is inequitable conduct, and the second is use of open source licensing as a defensive strategy. Now, of course, there are many things that can be overlooked, and there are many nitty-gritties and nuances in the overall uh, prosecution as well as litigation, both as a defendant as well as a plaintiff. But I thought these two may be important because sometimes they are overlooked, and sometimes these two aspects are also quite tough when it actually lands up into a litigation scenario. While theoretically it may sound very interesting, but I'll touch upon one aspect when we try to establish that there was a breach of the duty of candor, etc., under inequitable conduct. It is not as easy as said, right? I mean, in order to prove this, you have a long discovery process. There are a lot of, depositions, etc., which becomes so important for us to prove the first part. And the second also is not so easy, but these are quite interesting. And people who want to pursue their career in prosecution, litigation, etc., will come across these aspects, and I thought these may be important for us to discuss. Now, under equitable conduct, what is important to know is under US patent law, under 37 CFR 1.56, which is also popularly known as Rule 56 of the US Patent Act, where we talk about inequitable conduct, and it basically means that. And let's look at the first box. An applicant for a patent is under the duty of candor in dealing with the Patent and Trademark Office, which essentially means that there is a duty of candor which is expected from the applicant. And if the applicant is not following this duty of candor, then there could be a reason for the patent to be unenforceable. And thereby, it's a strong defense from a defendant when a particular patent is asserted against the defendant. Now, what does this duty of candor actually means? The duty of candor could be in multiple ways, that you are not supposed to intentionally hide certain information which may be material for the applicant. Or let's say, for example, you are supposed to disclose all the prior art that exists on the date of filing, when the applicant is filing the patent application, and you're supposed to disclose this as part of the IDS. Likewise, you have, different other aspects, for example, listing of the inventors, or you are certain things which you are aware but you are not disclosing it. It could be unintentional or intentional, but all those factors, and we will come across those points in a little later, fall under the duty of candor. Now, if you are not fulfilling that duty, then it becomes a strong ground for the patent to be invalidated, and you're not supposed to get a patent. So it becomes an unenforceable patent. Now, so inequitable conduct is a breach of that duty. That's what is defined as inequitable conduct. Now, what happens if we are able to prove that the duty of candor was not fulfilled, which led to inequitable conduct? Then the patent is unenforceable. But however, in real world, it doesn't become so easy. There are two things that needs to be proved. One is the materiality of the undisclosed information, and the second is intent. Now, both these have to be proved. This is a two-pronged test, and it is not easy. And we will come to, a bit, come to the details of this in a bit. But there are two other things that needs to be, understood in terms of why this materiality or intent becomes so essential when you are filing a patent. Because when a patent is filed by the applicant, either directly or through a law firm or the patent drafter, uh, who is assisting the applicant in drafting the patent, he or she should be extremely careful in ensuring that all the details are captured what are essential for the patent, and it is validated by all the inventors. That's why, as a standard practice for people who draft and file patents, you would know that once the patent is drafted, we get all the information from the inventors, all the claims are drafted, the entire application is completed. We give the final draft to the inventors to formally sign off, saying that yes, is this final, is this the one that accurately describes your invention, something has been missed or not. And even the forms which are filed, whether it's the IDS form or other forms that are filed, these are supposed to be validated by the inventors. And all the inventors, not that the main inventor will validate and the others may say it's fine, one of the inventors have validated. It becomes extremely essential for everyone to validate all the information which may be material for the application. Now, this could be also one more aspect which I think I should cover in this slide, is that sometimes the linkages of foreign applications also becomes important. So you may be filing an application in the US, and the same application, let's say you decide to file in India, with of course whatever modifications or formalities needs to be completed for a country filing, you will do all of it. But if sometimes if you have unknowingly not fulfilled the duty of candor in one application filed in, let's say, US, that may eventually affect you for your national filings or foreign filings in other regions as well. So it is not that I can ignore, while duty of candor is something which is strictly monitored and followed, let's say in country A, but country B has no such norm. So I don't need to be careful in country B. I can be careful in country A, and that should be good. For country B, it will be easy for me to get the patent granted. It may not happen, because even in India, if you really look at Section 8 of the Patent Act, the patent examiner can actually ask for all the prosecution details of a foreign filing which may have been done. Now, if the duty of candor has not been fulfilled or followed in other countries which led to the abandonment of the patent, then that may act against you for the national filings. So therefore, it is not that it is restricted only for one country. Sometimes it may get overlapped in other countries filing as well and affect your patentability. Now let's move to the a little bit more detail in terms of what is the materiality. Now this materiality has a little bit of an history. So if you really look at some of the in the US as well, there has been some development in this two-prong test. It was not the way it is now. Earlier, it was little at a very high level, and then there were a lot of case laws which came, and it became little difficult, and there were little amendments that were made on this two-prong test. Now, materiality, if I look at the first one, if we read it together, information is material when there is a substantial likelihood that a reasonable examiner would have considered the information important in deciding whether to allow the application to issue as a patent. That means that the information that was withheld, a, a reasonable examiner would have considered that as an important information for the application and for deciding whether to grant this patent or not to grant this patent. That's pretty much the summary substance of what materiality means. Now, the second paragraph is also important. The standard applied in determining whether a reference is material is not whether the particular examiner of the application and issue considered its reference to be important, rather it is the opinion of a reasonable examiner. So it is the overall summary to this slide is that materiality it depends on the application and the content of the application, which is essential for increasing the likelihood of a grant. Now, if that is withheld, then of course that becomes a material information which may be withheld. So there is, of course, there is a case law which in the US it is called as the Therasus decision, because of which these kind of transformation or amendment has happened over time on this two-pronged test. And as I was saying, in as foreign filings also become so important, that sometimes there are case laws where the foreign filings have been impacted because of a default in the duty of candor in the prior application that was filed in another country. So so as a when an application gets prosecuted tomorrow, when you are prosecuting an application, and even it's not about just the filing, even during the prosecution stage, it becomes extremely important to get all the information, to be very careful about how you are responding to an office action or how you are defending your patent against the examiner. It becomes extremely important to have the right set of information from the inventors and ensure that you are submitting all your submissions have accurate, complete data, and there is no ambiguity which can tomorrow lead to someone saying that, yes, you have withheld some of the material information. Now, let's look at the, the next one, which is on materiality in litigation. Now, materiality is often established through the testimony of experts. Now, it is extremely important, as I was saying in the first slide, that while this is important, but it also becomes difficult at times to really prove. So sometimes it is through the testimony of experts. Sometimes it is also done through a discovery process. As all of you would know that in a typical litigation scenario, there could be a discovery process which is not only very expensive process, but it's a time consuming process. But through the discovery, there are cases where, if you look at all the case laws where this aspects was brought in during the litigation phase, there was discovery, and discovery led to a lot of information coming out in terms of whether there has been information which was withheld knowingly or unknowingly, and the duty of candor was not fulfilled, which led to inequitable conduct. So it is usually through discovery, and sometimes it is testimony through experts. Now, the examples that I was referring others, not citing prior art results, not citing the right documentations, offer for sale, public disclosure, wrong inventors, there could be a laundry list of things that will be that are included in the duty of candor. Next is intent. This is the second aspect, as I was saying in the earlier slide, that one is the materiality and the second is the intent. Intent again is, sometimes it comes through the discovery process or during the deposition, phase. Intent comes out. Now, intent is an independent element of this inequitable conduct in prosecution and must be separately established. And clear and convincing evidence of conduct sufficient to support an inference of culpable intent is required. Now, the earlier standard that was adopted in the US way back many years ago was that what they were expecting is that there was a negligence standard which is also called as should have known. So if by unknowingly I have tried to withhold some information which should have been known to me. For example, I am, let's say, filing an application and I have done a search, a prior art search to find out what is existing, or I may have some knowledge, or I may have done some work earlier, but I have all the prior art information, and all as in to the best of my knowledge, and I have disclosed it. Now, the earlier standard, if I'm considered an expert in this field, and for which I have filed, I'm filing this patent and I may have filed a lot of patents earlier, then the what the other party will try to prove is that you have missed one prior art which you should have known because you are an expert in this field and you cannot miss out this. So it was an intentional miss out. So it is a negligence act from your part. Now that standard has been reduced and we are talking about that the point that needs to be proved is that the intent was wrong or the intent was right. Now you are trying to deceive the patent office and that is what I need to prove, and it was a deliberately I have withheld some information and that is the wrong intent. If I can prove that, again through deposition to discovery or through expert opinion, etc., then I will be able to prove the intent and that becomes a good reason for me to invalidate a patent for which uh, we may be challenging that patent. So that's the other part of intent. Now let's look at one of the case law which you may know already. Now this is a very interesting case law. It's Nielsen versus Osram. Now it's why interesting, the how it went was, so the inventor came out with a great invention and he hired a patent attorney. The patent attorney started working with this inventor for a long time to understand the invention and analyze all the detailed documentation and then draft the patent application. Now, while the drafting was going on, the inventor somehow did not like the patent attorney's draft and felt that the patent attorney was not able to draft properly the way he wanted it to be drafted. So he took over from him and he continued the draft in his own style, and he pretty much filed the application on his own. Now, of course, when he was filing, there was people who assisted him, but essentially all what was required was not followed. Now, the duty of candor was missed. There were many, misses, I would say, if you look at what the court said, that there was misrepresentation, then, priority dates were wrong, failed to disclose relevant litigation, failed to disclose material prior art. Ultimately, it was a bad decision from the inventor, which led to the uh, invalidation of the patent. The patent got invalidated in this particular case. So therefore, in a normal scenario, when people get into these kind of situations where the inventors are not very happy with the draft, you have to give the reason why these many questions are asked, because obviously the patent drafter usually ends up asking a lot of questions, a lot of details. And as an inventor who has a techie mind may not be in a position to really work on so much of documentations, etc., because they have a different mindset. So it is important for a patent drafter to explain why all the details are important, what will happen if these details are not shared. So the duty of candor information or the requirement needs to be communicated to the inventors so that they are also aware that this is such an important aspect, and if not followed can lead to the invalidation of the patent. Okay, so this is on the intent in litigation, or the first one, the inequitable conduct. Let's look at the second part, which is on open source licensing as defensive strategy. Now, I'm sure many of you or all of you will know about what is this open source licensing. Now, open source licenses are available under various license agreements. So if I'm developing, a software, I can develop using open source as a backbone. I can develop on my own, and I can plug and play certain open source components, which I will use from what is made available publicly. And I may also develop something and I may contribute back to the open source under different licenses. So there could be multiple scenarios under open source. Now, what is important under open source is, while open source is freely available, but it doesn't mean that there are no terms and conditions. There are hundreds of licenses, different type of licenses that are available under open source, and each come with different type of terms and conditions and licenses. So when we are using open source for, or when the developers, software developers and engineers are using open source, they should understand the terms and conditions and the restrictions. And at the same time, when somebody is contributing back to the open source community, the authors or the developers should know under what license terms they are contributing back, what is allowed, and what are the restrictions under those terms and conditions. These are extremely important. And if these, I mean, it's not that I can do whatever I want. Okay, it is freely available. It doesn't cost me. So let me use the way I want, or let me contribute and I don't worry about anything else. That is not the open source world. Open source world is very complex. So people will need to know the terms and conditions. Now, what happens in an open source, world is, let's take a scenario where I have I have a patent on a particular technology, and I have also contributed the source code and the lines of code under a particular license arrangement of open source. Now, if I'm asserting my patent right against a third party, the third party may come back with a defense that I have used it from the open source, and I am not infringing on your patent because it is available in public domain and I have taken it from the open source world. So obviously there is no way that you can sue me. That now it is not a straightforward answer that becomes a straight win for the defendant, but it is one of the defense that can be done. And why? Because sometimes the contributions that are done by the open source, contributions that are done in open source by the authors or the developers may not go through a proper due diligence phase, and therefore they may miss out on certain things which may be there in a particular license agreement, which the inventors or which the developers would not know generally. Now, if you look at GPL, which is one of the very common open source licenses, and very good components in the open source world are available under the GPL, General Public User License. Now, if you look at the preamble or read the preamble of the GPL, it states Finally, any free program is threatened constantly by software patents. We wish to avoid the danger that redistributors of a free program will individually obtain patent licenses in effect, making the program proprietary. To prevent this, we have made it clear that any patent must be licensed for everyone's free use or not licensed at all. So the intent of GPL now, because the whole open source community or the open source environment works under the model that it should be made freely available for people to use, and it should be also made available to people to develop it further. That's how some of the open source components that we see in the software world are very powerful components because they have been developed by many people because it was made open. Now, the idea is that if you try to create a restriction by through a patent, then it defeats the purpose of the open source world. So therefore, what is important to know from our perspective is that if you are advising a patent assignee or you are representing a company who is filing a patent as well as they do open source contribution, you have to remind them that you have to create a strategy on what can be open source or why do you want to really open source when you have a patent or you want to file a patent on a particular technology, because both can coexist, but there has to be a strategy behind it. Otherwise you will not get the benefit of the open source. At the same time, you may lose the battle of a litigation tomorrow because the defendant will say that I have used it from the open source world. So therefore, sometimes companies may do different kind of strategies while they are contributing to open source. They may say that, okay, till one version I'll make it free, but if there is an upgraded version that somebody requires that is not available in open source, that I will license it out under a different license. And if required, if there is a patent that is backing up the technology, then I will also issue a patent license for that particular technology, and it will come as a package so that there is no assertion of patent rights. So there could be multiple strategies through which both a contribution and a patent can exist, but it has to be carefully thought through. And most importantly, last but not the least, it has to be thought through in terms of what is the best license under which you want to disclose, because GPL is one aspect. Then GPL, again, the terms and conditions changes from one version to another. So GPL version 2 will be different from GPL 3. Then you have LGPL, you have AGPL, you have Apache, and you have BSD. Other many other licenses are there, and you can create your own licenses also, which comes with different terms and conditions. So overall, you have to choose the right license properly. You have to understand why you want to contribute. If you have a patent for that technology, you will have to decide on what would be your patent enforcement strategy, or you don't want to do it, or you want to do it in a different way. All these have to be thought through before you are doing both the open source contribution and patent. Now, coming to the an example that I thought may be useful. This is my last slide. After that, we can move to Q&A. So company one sues company two for patent infringement. However, company one has contributed software embodying the claims of the asserted patent to the project covered by, let's say, Apache 2 dot license. As a defense, company two may be able to claim that it is using the software under that particular open source Apache license. Raising this defense can avoid liability. Now, again, as I said, that it is not a straightforward answer. It depends on a lot of other factors which will go as part of the litigation, but this is a strong defense that comes as a aid during an actual litigation. So these are the two things I thought I'll cover very quickly. Let's move to questions if you have.
Yes. So, sir, we have a question from Sayed who asks, would non-submission of prior art cited by other patent office be considered inequitable conduct before the USPTO?
Uh, other prior art by other patent office. Not necessarily, because sometimes the prior art which is cited by the examiner may not be the real prior art. Okay. So it need not be, because if it is relevant for you, if tomorrow, let's say you come with a situation where the defendant is trying to say that you have not disclosed this particular prior art which has been cited by the examiner in other country, right? Now I can always challenge saying that this prior art, I was knowing about this, but it's not even relevant. And look at the prosecution of the prosecution history of that application. The applicant has strongly defended that this is not a relevant prior art, and therefore this is not a prior art for my invention as well. So that defense will obviously hold water, right? There's nothing wrong on that.
Understood, sir. We're just waiting for more questions if there are any. Let's just give us 1 more minute.
Sure, sure, sure. I think we have
Yes.
some time, so we can wait. I can see one question. Uh,
Sir, do you want me to read it out?
yeah, I saw. Okay, this is on GPL, right? That's the one, right?
Yes.
Okay. I have two questions. Can you shed some light on GPL license type? Uh, Question two, if company A is a service provider for company B. Okay, let's take the first one first and then the second one. Okay, so I think GPL licenses, there are, three versions that are available, 1, 2, and 3. Now, there are fine nuances. The way GPL works is that if you are modifying the source code of the GPL, the component that you've taken from GPL, then the modified version needs to be put back under the same license to public. So essentially, you cannot use a particular component of GPL and then do some modification and then don't contribute back. Then that's the whole purpose is defeated of GPL, that GPL has to be, given open to public. Now, the fine nuances of that is in terms of how do you do a reverse engineering. There are those nuances which are there in GPL2 and GPL3. But more importantly, there are also ways of how you can use a GPL license. It is about modification. So there are many components which you use not directly, but you are not distributing it. So in an open source, there are three scenarios. One, whether you are modifying it. Second is whether you are using is modifying or you are using it as is. The second important aspect is whether you are distributing it. And if you are distributing it, then how you are distributing it. So in a scenario where, let's say, there are softwares which does not combine a GPL component, but it only calls and do a plug and play. Now, if you do a plug and play, and let's say I give my component to my client and I say that in order to run this, you can download this particular component and plug and play and use it. That means I'm not distributing it, neither I'm modifying it. Now that is a much safer game because you are actually not modifying, you're using as is. So that those fine nuances of how you're using an open source component, how you're distributing becomes important. There is this concept is also very clearly coming out in AGPL license. Now AGPL license, what happens is if you're using something over an internet, I host a software in India and I'm asking my client in US to access it. Now, whether that will be constituted as a distribution under AGPL, it will be. So, but in other components, it may not be. That is not termed as distribution. So these aspects have to be very clearly brought out in the different versions, which keeps on changing. The second part is if company A is a service provider for company B, what precautions should company A to avoid IP infringement? This is a very broad question. Now, when you talk about IP infringement, there could be multiple, situations. But what is important is that if you are doing a custom development of a code for your customer, which is company B, then you have to first ensure that the code is a genuine custom developed code. If it is dependent on third party, let's say it could be two. One is it could be an open source that we talked about, then you will have to look at all the terms and conditions of the open source licenses from where you would have picked up. Or the second is if you have taken from a licensed in from a third party, a commercial third party vendor, right? Then it will come with certain terms and condition. And you have to be careful that you have got all the rights under that license to sub-license it to your client, right? So if let's say I'm developing a software and I need certain components from Microsoft, I'll get into a license arrangement from Microsoft, and I will ensure that whatever I'm taking from Microsoft, I should be able to license it out to company A, which company B, which is my client. And third, but the other part, which is not is important, but it's not so easy to do because it's an expensive affair. There are many companies who would do let's say a freedom to operate analysis to ensure that there is no possible threat of a third party patent infringement. So whatever you're doing, you have to do a search to figure out that yes, you have developed something, but you are not violating the patent right of a third party. You can do a freedom to operate analysis of infringement check, those kind of things, but it's not that easy to do. It is more than easy. I think the cost and time becomes very critical. So if you are really doing something critical, it might be worth doing that kind of an analysis also. And I'm only talking about patent infringement. If you're talking about IP infringement, there could be other infringements also. There could be, trademark violations, there could be compliances issues, etc., which is a long discussion, but I'm just trying to be a little brief on the patent infringement part.
Thank you so much, sir. I think that answers that question. Rohit is also asking for your views on 3K when algorithm, business methods, and software programs are granted as patents in India.
See, my view of 3K, if you really ask me, is that while the it is not as easy to get a pure software per se patent in India, but at the same time, I think there has been a evolution in India in terms of how examiners have started looking at a software patent. And I find it very logical if you ask me, because what is important for the examiner to know is not to reject a software patent directly just because it's a software. So, let's reject it. Now, how the application of the algorithm is, analyzed by the examiner, that becomes important. And more importantly, how you draft a particular patent claim to come within the boundary of what is there in 3K. That is very important for a drafter or a patent drafter to understand while they're filing software patents. But there is also a long way to go, because with the new technologies coming into in the software world, patent examiner needs to know that going by just the books of how 3K is interpreted and the use of a hardware, etc., is not that easy in the evolving technologies. In the software evolving technologies, it is very important that a patent examiners also understands the nuances, the fine nuances of what are the new developments, how the software interaction happens within a particular software technology. That becomes essential for them to play around. So overall, I think to sum up, it is not that bad, but we have a little way to go in terms of improving it further. But I think more importantly, the rules and procedures under how to interpret 3K, that there is an opportunity for us to strengthen.
Thank you, sir. Thank you. That answers my question. Sayed also wanted a follow-up on his previous question, which related to the USPTO and non-submission of prior art. He asked that if the other patent office finally refuses to grant the patent based on that prior art, and US patent is granted in the meantime, would I still carry the risk?
No, you won't. You won't, because that's a prosecution strategy. You have to understand that the duty of candor will come during a litigation phase, right? Now, of course, the grant of a patent is a country-specific grant. It will depend on multiple factors. So it is not that, because one patent office is granted and another patent office is not granted, there's a potential risk. If during the litigation phase, what we need to be careful is that whether I have tried to withhold the material information intentionally. If that is not done, then I don't need to be worried about. The patent can be granted in one country and may not be granted in another country.
So the duty of candor then starts as soon as the litigation process is commenced and not
No,
before that.
no, duty of candor will always be there from the stage of application filing. But you are supposed to follow the duty at the time of filing, and as long as you have done this, the later part is not in your hand, right? Now tomorrow, let's say there is some patents which get cited by country A, another set of patents get cited by country B. During litigation, when somebody is looking at the entire history estoppel, they will look at all of these data and they are all public. This is not that I disclose certain things to examiner, which is what he cited, right? The patent examiner has also done his due diligence to find out prior art.
Understood, sir. Thank you so much for that clarification. So I suppose we don't have any other questions. So would you like to share with us your concluding thoughts?
Yeah, sure. So thank you so much once again. I hope this session was useful, and though it was short, but of course there are, if you are interested, there are a lot of case laws around this in terms of what are the best practices around duty of care, etc. But I think it was a good session. Thank you for all the questions. And if you have any follow-up questions, you can always reach out to me. I'll be happy to address and answer. Thank
Thank
you.
you so much, sir. It was great having you here today.
Thank
Thank you
you.
so much.